Thank you everyone for joining this workshop. My name is Sharon Gugi. I'm the marketing manager at Nairobi Garage. It's an honor to have you all today to mark World IP Day. And today I just want to tell you a bit about who we are as Nairobi Garage. We are Africa's biggest, coolest co-working space and innovation hub and co-working community. So we believe that co-working drives innovation because whenever people share physical spaces, they're able to collaborate in different aspects and to be able to just create a bigger network. And as we know, your network is your net worth. So today we're going to be having an interesting panel discussion that will be moderated by Mr. Jesse Muraya, who's going to come into right after this. Feel free to ask any questions on the questions segment. We have polls at the end that you can answer to so that we can keep this session as interactive as possible. And thank you so much for joining. Enjoy the session. So Mr. Jesse, welcome.
All right, awesome. Thank you so much. So at first, I want to start by thanking our host for today. This is Nairobi Garage and Sisule Advocates for being able to bring this amazing session on board. So my name is Jesse Moraya. Maybe a quick brief about myself, if that wasn't mentioned. I'm a representative of Kenya National Chamber of Commerce and Industry. I'm passionate about entrepreneurship. I'm passionate about youth. I'm passionate about innovation. And other than that, I'm also an entrepreneur myself. I do have various interests, all the way from health tech to enterprise ICT and also in construction as well. So these are conversations that I'm very, very passionate about. And I do hope that you guys will be able to gain a lot of value from being able to join this event. So yeah, that's enough about me. I know you guys are coming here to actually listen to the amazing panel that we have. So even before we get to that, I'd like to give you guys maybe a quick brief in terms of housekeeping. The panel session shall give or take about 40 minutes. Then we shall have the rest of the time, about 20 minutes for Q&A. So feel free to engage. There's a chat platform. There's a chat feature on the application here. So if you want to bring in any sort of questions, either use the Q&A, question and answer platform, or the chat platform. You want to engage with each other. So feel free. And then I'd also like to advise the panelists who are coming on board, just to all of us to ensure that we keep our microphones muted so that we can be able to have an engaging session. So if you have any burning questions, just throw them on the chat and the panel will be ready to answer. So even before I invite the panelists, let me just give you a quick brief about World Intellectual Property Day. This is an occasion that's observed annually on the 26th of April. The event was established by the World Intellectual Property Organization in the year 2000 to raise awareness around patents, copyrights, trademarks, design impacts on daily life, and to celebrate creativity and the contribution by many creators and innovators around. So this conversation shall be very Kenyan for today. This shall be an African conversation, because I do believe that a lot of us do have a lot of innovations, but we don't know how to be able to protect. The number of times we go on we've seen in the press, we've seen on social media, conversations around, for example, we have some of our politicians trying to copyright some certain words like Allah and other things like that. So I do want us to be able to look in and explore such conversations. So this year's World Intellectual Property Day is themed focus on IP and youth innovating for a better future. So I do hope this actually is able to bring value to you, and you're able to learn a thing or two about being able to protect your innovation. So without further ado, I'd like to introduce our speakers. So the first speaker we have is a representative of Kenya Copyright Board. So his name is Paul Kaindo. I don't want to go too deep into his introduction, because I do believe sometimes when somebody is given the opportunity to be able to introduce themselves, they do a better job. So we have Paul. Next, we have Francis Mushina from mudondo.com. Next, we also have Shiruma Mbare. I do hope I'm saying your name right, who's a fashion consultant. And finally, we have Sisule Musungu, who's a managing partner at Sisule and Associates LLP. So once again, thank you to all the panelists for being able to join us here. And we do hope that we'll be able to have a fruitful conversation. So even before we start, I'd like to first start by asking Francis Mushina of Mudondo to be able to introduce himself and a bit about what they do at mudondo.com. So Francis Mushina, over to you.
Thank you, Jesse, and thank you so much to our panelists. Thank you, Nairobi Garage and Sisule Advocates, for having us. I'll go straight into it. My name is Francis Mushina, an IP and entertainment lawyer working at Mudondo.com. what is mdundo.com. Mdundo.com is a music service which is available on both web and app, available to millions of users to stream, download, and access DJ mixes. We have an audience of close to 13 million people, more than 100,000 artists, and around 100 labels and distribution companies. How do we innovate, or how do we make sure that our creatives are in the space of monetizing their IP? Simply by licensing that content, and I'll get into that in a few more details as to how we do license that content. But again, my name is Francis Mushina from Duno.com. Thank you.
Okay, amazing, Francis. Next, I'd like Sisule Musungu to introduce himself and also the organization that he represents. Over to you.
Good morning, everyone. Thank you, Nairobi Garage, for hosting us. Thank you, everyone who's joined. Thank you to the panelists. My name is Sisule Musungu. I'm the managing partner at Sisule and Associates, and the team leader for intellectual property at the firm. Sisule and Associates is a medium law firm in Nairobi, specializing in commercial law. In commercial law, intellectual property, contract management, litigation, and arbitration. We are grateful to have you all. Happy Intellectual Property Day, and welcome to this session.
All right. Thank you so much. Next, we have Shiruma Mbare. Over to you. Introduce yourself and a bit about your background.
Okay, good morning, everybody. My name is Siru Mambare. I'm a fashion consultant based here in Nairobi, and I'm really happy to be here today. Thanks to Nairobi Garage for hosting us and for putting this together for World IP Day. I work in the fashion sector, and I work with organizations like the Kenya Fashion Council, Fashion Agenda Africa. I also work in film. So for film, I provide wardrobe styling services, and that's for the advertising sector as well. And I also do the same thing for one-on-one individuals, you know, from personal shopping, personal styling, making sure people look their best when they go out to do what they need to do. So that's me in a nutshell, and I'm looking forward to getting to hear more and speak more today.
Awesome, thank you. And can you imagine the panel is not over yet? We still have Paul. So Paul, please introduce yourself.
Thank you, Jesse. So my name is Paul Kainda. I'm a senior legal counsel at the Kenya Copyright Board. I practice in the area of intellectual property, specifically copyright and related rights. Now, the Kenya Copyright Board is an establishment of the law. It is established under Section 3 of the Copyright Act, and the functions are provided for under Section 5 of the Copyright Act. And among generally what the Kenya Copyright Board is that we administer and enforce matters related to copyright and related rights in Kenya. And more specifically, we do things like licensing and supervising the activities of collective management organizations. We do maintain a database of copyright holders together with their works. Unfortunately, we are only based in Nairobi. We haven't evolved. However, because of technology, we have managed to open up our services to the whole country. So thank you so very much, the organizers, for having us. And I'm excited to participate in this panel. Thank you.
Okay, thank you so much. Thank you so much, Paul. Yeah, so to the rest of the audience, just to know that you people are still with us, please feel free to, actually, yeah, everyone, please just go to the chat platform and maybe wave or give an emoji so that we can know we're still together, even as we engage our panel. And then start thinking about your questions, start setting yourself up, because I know you have some funny questions to ask. Yeah, so I'll start with my first question going to Shiruma around, the fashion industry, the creative sector. It's quite diverse, and we have a lot of challenges in terms of copyright infringement. And we do know that in Kenya, some people call us Kenyans, the copycat generation. So you can imagine if I come up, for example, with an innovation, I come up with a type of shoe, I come up with a type of clothing, I come up with a type of watch. In fact, this watch is called Sud. I remember I bought one, they have beads. However, a few months later, I did see there are so many other brands around the same. So we do have a lot of copycat culture within the fashion industry. So as a fashion consultant and a lead authority in that subject, how do you think people can be able to help protect themselves better when it comes to infringement of people's copyrights in terms of fashion? So Shiruma.
Okay, so that's very interesting that you have that as an example, because that's something that I was actually looking forward to bringing up. And as far as how can people protect themselves or their creativity when it comes to IP rights, actually, I'll be looking forward to hearing that from our learned friends. However, it is a challenge in the industry, and just that, for example, and because we have this thing of tweaking versus inspiration, which I suppose is a question as well from my end, or on behalf of the industry, where people say, oh, you know, I've tweaked at the design a little bit, or I was inspired by this design. And so there's that thing where creatives might not feel like as if they're doing anything wrong. But I feel that it stems down to perhaps the process of creation, of ideation. If a creative person is aware of, you know, the creative design process, then there is no need, there would be no situation where we have the exact same product being produced by other people. And just to speak on that specific example, and this is an issue that spans especially across the accessories sector when it comes to creating. We have artisans that we use often to, if you have a jewelry line, a leather line, things like that. For example, like the suit watches, you know, it's beading and it's leather, and then you have the watch. And I absolutely loved the idea. And so a lot of people did take it up, but then you'll find that the artisans that you use, perhaps a lot of them are based in Kariokor market, and they have the skill set to bead and to create these things. So you go, you create your idea, you go take it to them, be like, you know, this is what I want. And you make sure you, like, you know, really finesse the process that they go through, only for somebody else to come to the market and they see like maybe your sample and they're like, I want that. And then they're not able to, or they're not willing to kind of be like, no, actually that belongs to a different client, come up with your own design. So I think there's a flaw in the process, if I could say that, the process of creation and also the process of production, where a designer can actually be able to protect their original designs. Because I actually went to Kariokor market one time and I found the suit watches at Kariokor, so you can imagine.
All right, thank you. And so they've not paid us to advertise for them, but they're really great watches. Yeah, so I'll throw this to Paul, our learned friends. It seems like this panel is full of learned friends, but I don't know if some of us, like Shiruma and I, are learned in any way. I think we are anyway. Yeah, so Paul, first of all, even before you answer in terms of how people in the design and fashion industry can protect themselves, maybe you can also give us a quick brief, I mean, about what IP is in general. You know, just explain to us, because I believe some of us in other areas, we do hear the word being thrown around, but we're not sure exactly what that is. So please explain to us what intellectual property is.
Okay, yes. Sorry about that. Thank you, Jesse. Now, just to briefly describe what is intellectual property. Intellectual property is actually, there are two types of intellectual property. Generally, intellectual property is intended to protect the intellectual creations of the mind. They are divided into two. We have copyright, and then we have industrial property. When we look at industrial property covers aspects like trademarks. We have industrial designs, and we have the patents, which in Kenya are actually protected, or the administration and enforcement of industrial property is done by the Kenya Industrial Property Institute, whereas copyright is actually administered and enforced by the Kenya Copyright Board. So generally speaking, intellectual property is intended to protect or to grant rights to creations of the mind, generally speaking. I don't know whether I can just describe in details what copyright is all about, because it has a direct relation with fashion design, like my colleague has actually mentioned. Now, copyright protects the original expressions of an idea. So, as opposed to industrial property, which protects the idea itself, copyright protects the expression, how you have expressed that particular idea. For example, in fashion design, you may have an idea, create a kind of a jewelry, but until and unless you put that idea, you actually express that idea, it is not protected. Another example of use is if, for example, you have an idea about a movie, or probably you want to write a book. This book is about a love story, ex met wife, somewhere they fell in love, married. That is an idea, but it is not protected. Anybody can actually come up with a book that has the same storyline, but the way you express that particular idea is not, is what is actually protected at a copyright. But the key point here is, what you need to note is that copyright protects the expression, how you have expressed an idea. Unlike industrial property, patents, for example, you protect the idea. Nobody can reproduce or make something that that is protected at a patent or industrial design. So, in brief, that is a brief description of what intellectual property is, copyright and industrial property.
Okay, let me not let go of you too easily. I think there was also a question posed by the previous panelist around how to protect your designs in the fashion area or the fashion sector. Anything around that, Paul?
Yes. Yes. Now, in copyright, you can only protect. Remember, an idea. The copyright protects an idea as soon as you express it. There is no legal requirement for you to go through some formalities for that expression to be protected. So the idea or the expression is protected automatically. So you need not follow some procedures such as registration. However, we do advise people to register their copyright or have some form of protection, which you can actually use as evidence in court. So what registration helps in is that it provides evidence of ownership of that copyright. So other than that formality for registration, it is advisable that every kind of agreement or any kind of relationship you engage with other people in the course of your creation, you ensure that you do that through written contracts. Written contracts are very, very important. Most of the cases that we receive as complaints are usually between friends, that guys just met and they decided to engage in a creation, maybe music, or create something that becomes a copyright work. But then midway, there is a lot of money, and of course, the devil comes in when there is a lot of money. And now they can't actually agree. So they come to us, and the first thing we ask is, what did you agree? So it is my word against yours. There is nothing written. It becomes very difficult. But the Kenya Copyright Board, what we do offer mediation services. And at the moment, we are in talks with the World Intellectual Property Arbitration and Mediation Center to be able to provide us with support in providing for mediation, even virtually, where people don't need even to be physically present in one place. So registration is one of the key. Then monitoring your work. Just because you have created a work and you have registered it, you have just released it in the social media or anywhere, don't lie back and say that now you are protected because you are registered. You need to monitor how your work is being used. If it is on social media, who is sharing it? With who? Are there other people who are actually using that work or selling your work? So without monitoring, you may end up losing a lot. And in addition to monitoring, you need to take action as soon as you realize that your work is actually being infringed elsewhere. So those three key things are the most important: registration, taking action, as well as having written contracts and using lawyers, of course. Thank you.
All right, thank you. So registration, taking action, contracts, monitoring, and using lawyers. And it's a good point actually now to be able to jump into the lawyers into the house. Sisule advocates. Funny thing, I actually got to learn about Sisule because I did have an innovation that I actually wanted to protect. So I reached out to them, actually asking them whether or how is it possible to be able to protect my innovation. That was around software being able to protect a specific algorithm in terms of AI. So that's a good way to actually just jump in, just mentioning that there are a lot of young inventors and innovators out there looking into protect software, internet business models with patents and trade secrets. So are they the most appropriate means to secure these ideas through going through such, or there are other options? Mr. Sisule, over to you. That question goes to you.
Thank you, Jesse. I think there are a lot of young people, and we are in the digital age. I think the current crop of people are called digital natives. And so, yes, there's a lot happening in that space. And everyone thinks about patents for software and in this space. The challenge, I think, one of the better ways to think about it, especially in that space, is that copyright might be more applicable in some cases, because since once you publish or you express, as Francis just explained, you express the idea or that an algorithm, it's fairly easy for someone to work backwards to arrive at what you are dealing with. But if you've coded, the code is protected by copyright automatically, as Francis explained. And so the more important part becomes the monitoring, the contractual issues around it that you have to deal with. In terms of business models, it's similar. It depends on whether you've expressed it, and if someone copies the original idea, you can be able to defend yourself. But I should mention that I think that the development of the law and the development of technology are at a different pace. The challenge we face, I think, is that the law is quite behind the actual technological developments. And the challenge is, one, in the local context, you could move things a little bit faster, but a lot of these things are global as well, or regional. And so you need regional or international treaties to be able to protect yourself around the world. And that takes a very long time. There are treaties that take 10 years, 15 years or more. And so I think for the youth, especially who are innovating and creating in the digital space, we need to think about how to move faster in developing the standards and rules that can better protect the creativity that we are seeing.
All right, thank you. Wow, I like that word, digital natives, and that's the truth. That's where we are in this sector, and that's a good place for me to be able to now go straight to Francis in terms of he is involved in an organization called Dundo, which I believe is in the digital space in regards to music. So maybe just a bit about Dundo, but also a bit about we may be having. I've seen here on the chat platform. On the polls that we do have a few people in the music industry within the audience. So as a musician, how best can you be able to protect whatever it is that you have, especially in this streaming era where everyone has access to your music, everyone can be able to download your music and share it out. So how best can you protect it using IP, or are there also other mechanisms? I mean, we've seen people coming up with things like NFTs and stuff like that. So feel free to share some knowledge and drop some wisdom on that.
Thank you, Jesse. So to explain that point, I think I'll go straight into what both Kaindo has intimated and Mr. Sisule, that number one, we are saying that one, are you proactive in your registration?
Sorry, we can't hear you clearly. Your microphone seems to be disconnected.
Check. Now, better?
Not yet.
How about now?
Not yet.
Just hold on for a second.
All right. Sorry about that. Yeah, maybe you can try disconnecting your earphones. Just for the
I don't know if you can hear me now. Better? So I'll try to project. Number one, Mr. Kaindo has intimated to, are you a proactive creative? So if you are in the music industry and you are an artist and you wish to monetize your copyright, how do you go about it? Number one, do you have your music, or do you have paperwork towards your music? Do you have split sheets out of studio? I know a lot of times people get into studio, make a big hit, and then not have paperwork for it. So what documentation do you need to rely on when you're in studio? It's a split sheet. So once you have that document, a split sheet is basically a document that says, I sang the chorus, he sang the hook, she sang a verse. So once you have that document, take it. Then if it's, whether it's a song or an album that you have, please go to the Kenya Copyright Board. Registration is free. Again, make sure that you have proof of ownership. So that's what it is for you, that this is my song, I did this, and this is the split sheet agreement that is tied to this copyright registration certificate. So again, are you a proactive creative in that you know that people are going to pirate your songs? So what steps are you doing to ensure that they are not pirated? And we at Mdundo, what we do is that we have a partnership with an organization, a global organization called Audiolock, that if your song is on Mdundo and it's the best performing top 1,000 catalog within 10 markets in Africa, that song is registered on that platform. And if there's an illegal website, an illegal blog that does not have the proper license to monetize that song, those sites are taken down. And what has happened is that we've taken down close to 2 million illegal websites, that is sites that are blogs that are monetizing content without the copyright owner's consent, and that traffic is redirected to Mdundo for the artists to make money with their copyright legally. So those are the steps that we're trying to do. That number one, be proactive, come with proof that if your song is being monetized on a digital service provider such as Mdundo, do you have proof that this is your song, this is your IP? Then if you do, upload and then monetize, and look for platforms that are taking care of your copyright, such as Mdundo, that yes, it's good to have music on all the other services, but what is the competitive advantage of us as a digital service provider is that we come in and we are fighting piracy, which is one of the biggest things that we are trying to do. Number one, we have 3 pillars according to our mission statement. We are providing structure, legality, and income to the sector. So at Mdundo, any artist who's on the service is basically walking the talk of making sure that, are we fighting against piracy? Are we changing the consumer habits of consuming not illegal music, but now music that has been licensed properly and is being monitored the consent of the copyright owner? I think I'll leave it at that for now. Thank you, Jason.
All right, thank you so much. Sorry, let me ask my colleague to mute his microphone, Francis. All right. Yeah, thank you so much. So especially for musicians, you do see that in terms of some of the platforms out there available, like Mdundo, they are actually able to work with you towards helping you protect your music. But there's some prerequisites that you do need to have, of course, being able to show proof of ownership of that music and being able to actually, put that down in a written format so that there's actually proof of that. Yeah. So my next question we'll go back to Paul. In terms of in this era of content creation, for example, and streaming media. I want to flip the script a bit and turn it over to the other side. Right now, we've been talking about defending the people who are actually creating these innovations. But on the other hand, we as users, we frequently, quote unquote, pirate a lot of this stuff out there. So what's exact liability in terms of yeah, the liability in terms of the user or the people who are actually infringing on these rights, and how should we as users be able to better promote the sectors out there and promote the local content creation in our industries. So Paul.
Thank you again, Jesse. Now, allow me to start, as opposed to starting from the user side, allow me to start from the copyright owner or the right holder. And like we said initially, it is their duty to monitor and know exactly what they are doing with their work. Most of the people, what they don't do is that they don't read the terms and conditions of the platforms they use in the digital platforms. There are some digital platforms, you put up your music, you put up your video, you put up your photographs or such designs, and you don't know that you're giving up all your rights in that particular platform. Then later on, you come complaining that your work has been infringed. All we do is open up the terms and conditions of that platform, say this is exactly what you signed up for. So what I would advise right holders at this point is to ensure that they carefully read the terms and conditions of the platforms, digital platforms that they use. And this is where, and I'll keep insisting, it is not that I'm promoting lawyers, but make sure that you use lawyers who will know exactly how to explain and make you understand what these terms and conditions actually mean to you. So you'll know exactly what to put up in that platform or not. Now, as a user, the user may not have an exact liability. When I'm actually consuming work that has been infringed, there may not be liability on me as the user, the consumer of that particular work. I become liable when, for example, I share or I commercialize that content without the consent of the owner. The best thing, again, we have the internet service providers. Those providers, those organizations that provide platforms and enable people to share or computers to connect with each other. The Kenya Copyright Act, there was an amendment in the year 2019 that introduced the ISP liability. And it provided, one of the things that it did is that it provided for instances when an internet service provider will be liable for example, enabling an infringement, and also provided for protection against the ISPs. It indicated the instances when an ISP will not be liable when a work has been infringed on their platform. For example, an ISP, whatever platform that you are using, will not be liable if they have not initiated that transmission of whatever content it is or the material, or it does not select the addressee, or it simply stores that content and enables it to move from computer to computer, and does not have control of how the content moves. So in those instances, it will not be liable. However, Section 35B of the Copyright Act introduced a procedure, a takedown procedure, and a copyright holder, when they are monitoring their work and then they realize it is being infringed without their authority, they can issue what we call a takedown notice, which is provided for the Section 35B, that provides for what exactly that takedown notice should look like, to whom it should be addressed to, and how it should be served. And once it is served, the ISP or that platform has not received a counter notice from the person who uploaded the work, and it could be indicating that it is their work, which is not an infringement. So in those instances, the ISP is required to take down that content or that material within 48 hours. Should they fail to do so, then the right holder can take action and seek for injunctive reliefs in the High Court. The main challenge with these kind of platforms, you realize that copyright is territorial in nature. You will not apply the Copyright Act outside in Kenya, outside the territories of the country. These platforms, most of them are, the internet made it possible for these works to be easily consumed beyond borders. So it becomes very difficult to actually control these. And most of these companies, you realize they are also domiciled in other countries, the US, the UK, and other countries, China, for example. And the laws in those countries are different. So if there is an infringement and you need to take a court action, in most of the instances you may be required you may fight a lot of challenges because you may be required to enforce in the country where that particular company is domiciled. However, these platforms also have their own copyright policies. They provide for procedures in which you can make a complaint wherever there is an infringement on their platform. You can, for example, I know for YouTube, you simply go to, there is a form you fill, copyright infringement complaint. You fill it, and then you submit to them. Then they will review that complaint. You'll be required to provide evidence of ownership. And that is where, ladies and gentlemen, that registration comes in handy. So if you are registered, of course, you're able to prove that this work is yours. So they'll conduct their checks, and if it is an infringement, they will take it down. If it is not, then they'll let you know, and then you can decide what to do. So those are some of the things that in the digital platform, people may be able to use to prevent an infringement in this particular area. Thank you. Back to you.
All right, thank you, Paul. So you guys have heard it. There's so many mechanisms to be able to protect yourself. Maybe I can also give you guys a quick brief for those of you who participated in the poll. So let me just give you part of the results. So we did ask, how have you ever registered any of the copyrights or trademarks and patents? So actually 61% of you said no, and 38. Then in terms of the sector in which our audience is in, technology, most of you seem to be in the technology sector. That's 47%. And then a lot of you are actually in music. And then we do have also those in others. And then do you have any sort of intellectual property? So 56% people said no, and others said yes. So I take it this is more or less a vote of confidence, just mentioning that there are a lot of you who are actually very interested in copyright matters in terms of IP, but are not sure how to go about that. So that was just a quick break, just to be able to mention to you, some results. So we do have some questions from the audience. So Angeshi, thank you so much for your question. So I'll ask this question or repeat what Angeshi has mentioned. Why are creatives not proactive when it comes to registration and enforcement of their rights? So creatives, I'll talk to the creatives in the house. We've got a representative from Dundo, and then we also do have a representative from the fashion industry. So guys, I don't know who wants to take this first in terms of why are proactive not why are creatives not proactive in this sector? Okay, I believe Francis.
Yep. Can you hear me? Audible?
Right.
If you can hear me, I hope I'm audible enough. So number one, when it comes to the audio industry, this is something that I've had to do physically, is that because artists are recording in studio and they do not want to create to basically not have the right type of environment within studio, what happens, they call me to be bad cop. So I come in with the paperwork and they say, okay, fine, Francis is going to handle your paperwork, let's just continue creating the song. So that's proactivity. What we are seeing now is that many artists are not seeing, they're not taking initiative to be proactive with their paperwork, that they're saying that if we put something down, maybe the quality of the work maybe will be affected. Those are reasons I hear artists saying, number one, but I go in and make sure that paperwork is being done. To answer your question, why are they not putting things in paper? It's basically not treating their art as a business. If you ask me that, are they creatives treating their art as a business? And if you are running an enterprise, you must have paperwork to ascertain that you have ownership, so that when money comes in, you have proof of ownership so that you can monetize your art. So my simple answer is that creatives are not taking their art seriously. They're not taking it as a business. Hence, they're not putting things in paper. That is my response.
All right, thank you, Francis. And I think that's so relevant right now because I think creative sector globally is one of the fastest growing sectors globally. However, there's that question about being able to actually take it seriously as a business. Some sectors have done it, but others. You can think about content creation, for example. You have all these, TikTok millionaires coming up. However, are they able to actually tap into that? So I don't know, Shuruma, if you have any answer to that question in terms of creatives taking it seriously or not in terms of being able to protect the IP.
Okay, yeah. So what I'm going to say is, first of all, I agree with what Francis has said about taking the your creative business seriously. And for the longest time, fashion, for example, has been considered informal sector, and therefore even the players in the industry have sort of treated it as such. And it's even just more recently where we've had organizations really pushing for creatives, young designers to actually register their businesses formally, because you'll find, people, you just start your fashion line from wherever, if it's your house, and then it continues growing. And at some point, you'll probably get into some kind of trouble because you haven't done the necessary paperwork. But now there's definitely a lot more push in the fashion industry to make things formal, to make things, be like run like appropriate businesses, because then we're really trying to get the attention of the government. We're really trying to get the attention of, private sector funding and support and things like that. And obviously, when you start getting to such places, you have to show, your books, have been doing bookkeeping, have to have audited accounts, you have to do all these things that actually require you to have registered a business. So you find that a fashion brand can grow onto a certain point, and then when you get to a place where you can really expand, then you don't have your house in order. So definitely that thing of treating it informally does hinder us from getting involved in all the other legalities and things that come with actually running a creative business. And so because of that, then easily a designer will not be aware, or even a fashion stylist will not be aware of things like IP, intellectual property, and stuff like that, and knowing that they can actually register and monitor. And I think the other thing that sort of brings this is that because it's an informal sector, a lot of people will feel that they don't need to be educated, in what they do. And so, you'll say, I've always loved clothes, I love fashion, and so I'm just going to start my brand, or I'm going to become a designer, and I'll just get a few tailors, and I'll get some designs on Pinterest or whatever, and have them recreated. For me, this is something that I really insist that people ought to have training in the sector, because once you start training, once you start getting an education, you're actually exposed to all the other things you might not know if you just approach it in a Juakali way. And I think those are some of the main reasons why I think they don't take it seriously, because first of all, the business is considered informal. Secondly, there's very little training even in the business itself. Therefore, exposure to information that would support the business is just not is not lacking. But it does cause a lot of problems. And I'm still waiting for somebody who can explain to me, I don't know if it's going to be Paul or Sisule, about what's when it comes to tweaking versus inspiration. I was inspired by your design. I took your design and tweaked it a little bit, so maybe we'll get a chance for us to ask questions as well. So, because I have a few questions on behalf of the fashion industry, just to help people take it more seriously or break it down, so it doesn't seem like this big thing of intellectual property, and maybe if there's a lacking of understanding of how that really works or how it relates to your business, then it could cause people to just sort of glaze over when it comes to that.
All right, thank you, Shuruma. I mean, this is a very open session, so I'll actually allow you as a moderator to ask any of the other panelists in regards to the fashion sector, because I do believe you do represent others who are in audiences in that same sector. But before any of the learned friends answer that question, I'd like to ask the audience, maybe you can just put on the chat platform, either via yes or no, in terms of what do you think are the biggest impediments for you to protect your innovation? Is it cost, or is it knowledge? Yeah, and is cost a major factor, yes or no? So just feel free to put that on the chat, and we shall deeper into that. But for now, back to you, Shiruma. I think you can ask whoever it is that you wanted to ask your question around design.
Okay, thank you very much, Jesse. Okay, I have a few questions, and one of them comes to, so it was great to have the whole, from Paul, the definition of the different ways to have intellectual property, from protecting the original expression and also protecting the idea itself. So see, when it comes to design, say I'm a fashion designer, I'm going to have more than one design of something. It's not like coding an app. You know, of course you can have more than one app, but then say a collection has up to 25 pieces or 22 pieces. If I feel that each design is original, do I need to, first of all, patent the design, each of them, and then after making it, then that becomes the expression if I got that correctly. So then would that mean as a designer, I would have to register, first of all, the idea, the design, and then the actual expression of once it's actualized. And then, so, and that also leads into questions about the cost for registering each. And the collections are coming in and out. I'm churning out a lot of designs over time. So does that mean I have one for each? And then the other question, I hope you're noting them down, is to do with the, okay, original expression of an idea. So if the question on tweaking and inspiration, okay, so like we've talked about the sued watches, right? And although for that, I think that was just outright copying. And but we have instances where you find, say, somebody comes up with a design from the cut to the print they use and all that. And then somebody decides to be inspired by that design and they copy exactly everything, every single detail from positioning of buttons or flaps and belts and the length of the sleeve, and maybe use different fabrics, but to express the same thing. You know, as a designer, as the designer of the original product, do I have a right to, you know, bring up a legal issue if, say, I had actually registered the design? Because I think what I'm getting is, if I haven't registered, if I haven't copyrighted or patented my design, then I really don't have any legal basis of bringing an issue up. And you can correct me if that's wrong. And then the other question I would have is, say, for example, okay, still leaning on the same thing of tweaking. Say I come up with a cut of a dress, for example, you know, the sleeve is this length, the thing, it has the pockets here, and then it has a slit on one side, and then one hem is longer than the other. So like everything put together, though the little things may not be original in of themselves, but then put together, I've created something that's, you know, fairly new. So then if somebody takes that, the cut, and then decides to add some embellishment, maybe they decide to add some, like I'm wearing a beaded top, some beading on the neck or something, but it's the exact same cut as somebody else's design, would that be considered a new creation, or would that be considered an infringement somewhat, to some extent, of the original creation? And yeah, I think I will have a few questions, but maybe let me
Okay, thank
stop
you so
there.
much. Yeah, so I think we can try and put those questions together maybe in one, in terms of there's the aspect around about different designs and being able to, I mean, you have to copyright each one of them, or patent each one of them, or protect each one of them, or can you do it as a whole? And then there's also the thing about tweaks, which I think is also, you know, crosses across different sectors. I mean, you can imagine, like, for example, somebody comes up with a certain song, then they, certain kind of music, then they add a few tweaks here and there in terms of the kind of beats that have been added, or in terms of even of the beats per minute, or whatever it is, or even in terms of software as well. Somebody has a certain specific kind of code, however they make a few tweaks to it. So I think those can cut across different sectors. So maybe this can go to Sisule in terms of how you're able to approach that, and feel free to bill Shiruma for that question that she asked. Yeah, but anyways, Sisule, over to you. I'm kidding.
Okay, thank you. I think we'll share this with Paul. But to start off, In terms of the scenario that Shiruma has given, I think in most cases that would be infringement. Small tweaks that do not really show originality in the new design would still be infringement. But you also have to think about it in the way that knowledge and creativity grows. We always learn from each other. We build knowledge to existing knowledge. So in the intellectual property field, to allow people to build from existing knowledge, there are several mechanisms that are used to try and allow that to happen. So we have in copyright and in other IP categories what we call exceptions or limitations to how far your rights go. So the rights are not completely absolute. So if you, for example, sample music or you take just a beat, and different countries define what is a beat or how much you can take and build on from someone else and what goes into infringement. So there are instances where you could be able to sample, use part of someone's creativity without going too far. That is allowed. But as I said, the scenario you've described primarily would be infringement because you've essentially taken everything with a few tweaks. That would so it's the opposite of what should happen. You could take a little to then create an original idea, but the opposite side of taking most of it and tweaking would result in infringement, I would say. But as I've mentioned, you have to think about, I think we also have, especially in the current age, in the digital age, and when we are talking about youth and innovation, we are in the age of collaboration. A lot of collaboration is key in creating some of these products or this intellectual property. So we also need to think about intellectual property as a platform for collaboration. And that is because by intellectual property allocating rights to different people who come together to do something, it makes it easier to know who owns what, and when we come together, the totality, what are the shares for each person. So intellectual property is not just about protection. It is also a means that a way that allows us to better collaborate because we understand who has brought what to the table because of the rights they own. I think I can leave it there and pass it to Paul.
Right, thank you so much. Paul, over to you. Anything to add on in regards to what was raised there?
Thank you, Jesse. I would actually fully agree with my senior. What if I was arguing such a case before court? What we'll be looking at is the substantial similarity, the lack of originality. So if there are small tweaks, and then the larger work is similar to the original work, to me it would actually be an infringement. So the key ingredient here is the other work substantially similar to the original? If the answer is yes, then it would be an infringement. Now, again, I would like to distinguish between originality in copyright. Originality in copyright does not necessarily mean new, that's something that has never existed. Unlike in patents, where something has to be new or novel, that novelty or something does not have to be new for it to get copyright protection. It only needs to be original. Original in the sense that it is not copied. Remember the dispute, the Ed Sheeran dispute on the Shape of You case. So there was an indication that he had copied, but he was able to prove that he didn't copy. He could probably, of course, there are no similarities, but if you are able to prove that in as much as there are similarities in these and that, you did not, it is very hard. In the developed countries like the US, they're able to distinguish. Even the court will even listen to the musical composition itself and try to see whether there are similarities. The other party has to prove that he has never heard of this song, he didn't necessarily copy it. So originality in copyright does not mean name. It simply means that that work was not copied, and there was some skill, a level of skill that was established. Now, in relation to the registration process, and I'll put in the chat, I'll put the link to the registration platform, because I'm surprised that 9% of the poll respondents have not registered their copyright specifically. And I don't see a cost, particularly on copyright. On other things like patents, it would be different. But for copyright, there is no cost challenge. Because as we speak, the registration is free for now. Of course, I know in July, after July, there was a notice by the Kenya Copyright Board that there will be a charge. But the charge is not prohibitive at all.
Sorry, just say that again for everyone to hear.
As we speak, through the system, I'm going to put the link on the chat platform. The registration for copyright works is free, and the process is so simple that even a primary school kid would be able to register a work. It is free for now. In July, there are likely to be a cost because we are testing the efficacy of the system that it is being used by the Kenya Copyright Board, and it is actually very effective. As we speak, there are about over 22,000 copyright works that have been registered. The cost that will be put there is not prohibitive at all. So it will be between, if it is an individual, 100 to around 500 if it is accompanied, again, depending on whether it is a software or the like. But generally, it is not prohibitive at all. Initially, it used to be 1,000 per hour, but now it will be around 100 thereabout. So that should not be should not be an issue. So again, allow me to also mention something. When in the poll, I think there was a question on whether anybody, how many of you own any intellectual property. 59% said no. Chances are.
Sorry. Let me jump in a bit. Huh? You said 500 to 1,000. I mean 100 to 500,000 shillings or 500.
No. It is 100 shillings. Between 100 and 500 shillings. I'll not even mention 1,000 again. So it is 100 shillings at 500, depending on whether it is an individual or it is a company. So 59% said that they don't own any intellectual property. Chances are you own copyright, but you don't know. If you come from the era that I come from, we used to write a lot of letters to our girlfriends and even poems at songs. Those themselves are copyright works, and probably you still have them, or you don't have them, but you own copyright in those works. So if you have ever written a poem in your free time or anything related to that, you own intellectual property. Intellectual property, people assume that the intellectual property is just patents, trademarks, the like. It incorporates even those writings, those songs you sing in your bathroom and you decide they are very nice, go down and write them. Those are very nice songs. They are copyright works. Or you sit down and try to draw a dress, it comes out very nice. That is copyright work in itself. And in relation to that, I will speak. I think Suruma did ask about the registration. I think the process of developing the final product in fashion design starts with a sketch. Then at the end, you have the final product. The system that is at the Kenya Copyright Board will not be able to bring the physical or actual dress there. But the sketch or a photograph of the final product is what you upload as the copyright work. You take an image of that, and then you upload. You pay 100 bob. If it is you do it now, it will be not be charged anything. So for me, I don't think cost is an inhibiting factor. And I think it is awareness. Awareness is what is lacking. And I think we as the industry players need to do more and organize talks like these ones where we can actually ensure that we people know how to register their work. I think that's it for now.
All right, thank you so much, Paul, also for demystifying some of those aspects. So I think you guys had that right. And again, Paul will share that in the platform for those of you who want to know how to go about the registration. So my next question has also been asked by Mitch here, and I want to represent the techies in the house because I consider myself one. We've seen people afraid of going with their ideas to large corporates like the Safaricom, the Equities, just because there's this perceived fear that they will steal your idea or they have stolen other people's idea. So my question right now would go to Sisule, in terms of are those fears actually genuine? And also a second facet to that question, are there actually original ideas out there, or is it a matter of whoever it is who's passed to actually be able to create and go to market with that perhaps application or the idea that they had? So over to you, and then perhaps also Francis, if you can add on in terms of that, being somebody who's also working within the technology space, any experiences around that?
Okay, thank you for the question. I think the answer to the question is both ways in a sense. It is true that there would be cases where when you are dealing with big corporates and you are starting off in an industry, you don't have market power, and you do not take legal advice, you will probably share your ideas without any protection. And because you are competing with other people, it makes it more difficult. And as we talk about the youth on this World IP Day, it's even more difficult. So there are genuine fears that could happen, but there are ways in which you can deal with it. It's always useful to try and get non-disclosure agreements if possible, but sometimes it's not possible, as I've just said. Key to that, if you can get such agreements, it's critical that you document your communication with such entities so that you can demonstrate that was your idea, and it then will turn for them to show that they either developed that idea separately or it's someone else's idea. I think there are institutions that can also help, such as Kekobo, to advise on how to deal with these things. More awareness will help in dealing with those fears. But it is also true that these organizations of those sizes, like Safaricom, as you've mentioned, Equity, receive a lot of ideas at the same time that are similar, or relate to the same question. So it becomes difficult to be able to distinguish which exact idea was used. In relation to whether there are really new ideas out there, I think there are a lot of new ideas, and creativity continues to grow with new technologies. So there are really, yes, new ideas. In the patent context, of course, as Paul explained, it has to be something that has not been done before and could not be anticipated, obviously. In the copyright context, it's different. You could create exactly the same thing in completely differently without knowing about the other, and both ideas would be new and original. What I would advise, I think, as with technology, it's now much easier to know if something is really new. So we have databases, organizations such as the World Intellectual Property Organization, the national offices, as Paul has mentioned, these registration databases. You can search. There are searchable databases that you can check. If you are developing idea with keywords, you can be able to check that something exists. So before you go too far, believing that this is a new idea, we have better ways now that you can go to various databases, national offices, international organizations. There are also private databases. Some of them you pay for, others are free, that you can go to check just using basic keywords to know if there's an idea around what you are thinking about. And if it is, then you read what exists and see whether the improvement you are making will make it distinctive or something different. So my advice also is that before you go too far, there are now resources such as databases that you should go through to be sure. And that is why in areas such as patents, usually technology comes to the market 10 or sometimes more years since it was invented. And so if you went to the databases, you would know that those ideas already exist. But if you looked in the market, you wouldn't see that idea. So you would think that it's new because it's not in the market. But if you went to the scientific side, which is such databases, you would know that it exists. So we have the example that many people in Kenya think about is M-Pesa. And we have had arguments, people have gone to court to say M-Pesa is the idea. The technical process itself had been invented and patented way back in the UK. It was the implementation. In most cases, there were no regulatory frameworks to allow it to happen. It happened that in Kenya, there was a confluence of policy understanding that allowed it to be implemented, but it was not a new invention. So I think there are still new ideas, big ones, but for you to be sure, try to use the resources that we now have that are easily accessible, such as databases or including the registration systems in national offices to check. Thank you.
All right, thank you. That just reminds me. Was it the other day we have somebody, I think was it from South Africa, who got a very big payday out of the place called me from Vodafone Group, which was not billions, but maybe a few millions of shillings. So I found that quite fascinating in terms of they're actually able to prove that a court of law and actually given, although I do believe that they were employees or past employees of the company. Yeah, anyway, that's just a side note. I have one more question. Then I'd like to give the opportunity to Francis to be able to tell us a bit more about Mdundo, and also for Sule to give us a bit more about what, just showing you a video, just to give you a bit about how they can be able to help you protect your ideas a bit better. So for now, let me just do my final question to Francis. In terms of, somebody was asking, Mark was asking, say I record a song on Instagram Live as a recording session, then someone uses it as their own before I get a chance to actually secure it. Do I own it, and how do I actually recover the ownership? So, Francis?
Yes, thank you, Jesse. Like I've answered in the chat box, I think, first of all, Paul from Kenya Copyright Board has intimated that copyright need not be registered. As long as it's available to the public, you are now protected in terms of first to publish. So my answer, as I've put it there in the chat box, is number one, yes, you do have protection. Whether or not you have the registration certificate is another issue altogether, but it helps if you do have a registration certificate. So one, who's gone first to publish? Is it you or the person who has infringed on your copyright? If it's you, then the Kenya Copyright Board, number one, does have solutions for creatives. I believe Paul is here, he can echo me on that. But a lot of creatives have this scenario where once it's published, they ask, do they own the IP? And the answer is, were you first to publish? And if the answer is yes, then you should have mechanisms, either going to court, as Kaindo has mentioned. Number one, you can get an injunction, you can go to tribunals, and furthermore, after the fact, make sure that you have a registration certificate. It's good to have it before, but even if you don't, and you've you've still seen an infringement on your copyright, the best thing there to do is to ensure that, number one, identify when did that post on Instagram live go, when did it go live? Did it happen before or after the person who you claim to be infringing on your right is basically so I feel that should be in terms of, yes, you do own your IP, but you have to have methods of recovery. Will you choose to go and seek an injunction if it's being monetized? Will you choose to settle out of court, or to make sure that, number one, you have paperwork to prove that you are the owner of that copyright? I think that should be it.
All right, thank you, Francis. Yeah, I think we're also reaching the top of the end of this session. So I'll allow each person to be able to at least give their final remarks, and then also tell us how they can be able to reach you. And also, this could be also your 5 minutes of being able to also talk to the audience and tell them a bit more about how you can be able to support them and work with them. So I do believe, again, we'll get back to you, Francis. You'll be leading a short presentation on music sector, and perhaps even other sectors. I'm sure you're going to be amazingly from. So we'll start with Francis, then we'll be able to go to Paul, and then we'll go to Ruma, and then finally we can finish. So Francis.
Thank you, Jesse. And I'll summarize my comments into what do you need to do to protect your IP and what your IP can do for you. Look for your demographic as an artist, number one. If you're coming to Mdundo to get royalties, make sure that, number one, you have a foothold of what your IP has. Number one, are you registered? I know there are a lot of challenges when it comes to the CMOs. We won't touch on that, but likewise, are you able to identify who's your target audience? Number one, we as Mdundo, we have an audience of close to 13 million people that we can expose that one single song to. That's one. So what works for you? Is it the freemium model or is it the premium model? Are you willing to give out your content for free, have ads in between, but still gain some economic revenue out of it? That's why I was saying that we as Mdundo, we are contributing to the sector, not just structurally, not just legally, but also through income, that we feel that there's a gap in the Pan-African, not just Kenyan market, but the Pan-African market, that there are no structures, different models of licensing are all over the place, and artists are not able to make a decision as to who is going to listen to my music if I put it on Mdundo. So again, being a distribution service, we make sure that, number one, your rights are non-exclusive. As you can see there, we have an audience of close to 400 people who we are reaching. We've only barely scratched the surface of 15 million people, and we are ongoing. So are you looking to expose your catalog? Are you looking to monetize your intellectual property rights across worldwide, basically, both on web and on app? And have you identified who is going to consume your music? How many people? Now, as a business model, we do have our premium version of for consumers, and this is in partnerships with telecommunication companies in Nigeria and in Tanzania. That's Vodacom and MTN. How does this impact you as a creative or as a musician in terms of adding value to your copyright? Number one, it's more money. That we are saying that as Mdundo, you'll make money 3 ways: streaming, downloading, and DJ mixes. DJ mixes there is the premium product that adds more revenue to your pocket as an artist. That if you're on Mdundo and if you're on iTunes and Spotify, you can make more money on Mdundo. Why? Because there are more revenue streams of making that money. Now, in terms of how we make money, we get it through advertisement revenue, both direct and indirect sales. So we are not just giving away your content for free, we are licensing it properly and giving it back to 13 million people who are willing to listen to a 5 to 10 second voice ad that will be able to give you money as a creative. I think I'd want to leave it at that. Not unless there are any questions for me. Please feel free to reach out to me on email, francis@mdundo.com. I will leave my WhatsApp number on the chat box. Thank you very much. Thank you to Sisule Advocates. Thank you so much, Nairobi Garage. Thank you for having me. Cheers.
All right, awesome. Thank you so much, Francis. So you guys have had it from Dundo. Compared to other platforms out there, you'll be able to get more revenue out of the demographic that they have. So thank you so much, Francis, for that and for your final remarks. So next we can go to Paul.
Thank you. So my message this day, this IP day, the theme notice was IP at the Youth Innovation for a better future. For the creatives here, I think you should make a decision at least today to take action and see your work, see your creativity, see your creations as innovations as a business, and as something that can sustain you and sustain even your generation for so many years. Because like for copyright work, you're protected even 50 years after you die. So this is a legacy you can even leave to your dependents. So make a decision today to ensure that you protect your work. You can actually do that by today starting to by registering. Notice that the fee is free. So you can follow the Kenya Copyright Board through their Twitter handle, that is at Kenya Copyright. Their Facebook handle is also Kenya Copyright Board. You'll get a lot of information there. You'll even get the contacts for the Kenya Copyright Board there. If you want to talk to us, you can always call us to speak to a legal counsel, and you'll get assistance. If you are facing any disputes, don't shy off coming to the Kenya Copyright Board for mediation. We do conduct mediation, and like I said earlier, we are trying to talk with the White Arbitration and Mediation Center to actually conduct these mediations. There is no fee for mediation, just to clarify that. So if you have a dispute, you can refer it to the Kenya Copyright Board for resolution. And we have even seen law firms also actually advising clients to refer the dispute to the Kenya Copyright Board, and we have resolved them within hours or even within minutes. So we are open 24/7, being a government office. We are at the office of the Attorney General. So you can call on us or send an email to us at Kenya Copyright Board. At the email, you find it at the, if you go to our Twitter handle, you find our email details there. So thank you so very much for the organizers. And I'm hoping we are going to conduct these kind of sessions.
All right, thank you so much, Paul, and thank you for demystifying copyright in terms of even cost and just the process of doing that. I mean, right now, personally, I'm probably going to copyright so many things in my life right now. So thank you for being able to clarify that aspect. Yeah, so next, Roma, final remarks, and also perhaps also how the audience can be able to reach you.
Thank you. Okay, so my final remarks obviously would be for the for the fashion industry in the creative sector. And well, I'm personally a champion of Made in Kenya fashion and a promoter of the Buy Kenya, Build Kenya movement. So this is a big area of passion for me. And I would like to encourage fashion designers to have a bit more of an engaging design process, where that involves creative research, where you're able to have, a mood board, sketchbook, where you've really kind of fleshed out the ideas that you have, rather than going from, boom, an idea in your head, sketch it, make it. It is highly likely not going to be original, and you'll be highly likely infringing on somebody's intellectual property. So it does help to actually flesh out your ideas and then come up with a congruent collection that's more original, because you have taken time to think about it. Not only does that benefit clients who can at least wear original designs from different designers without having to choose from the same options, but it also gives you actually proof, if ever there's a dispute, that this is your original creation, when you're able to show the kind of creative process you have gone through in order to come up with your final product. Okay, so in closing, I'm a fashion consultant. I work with Made in Kenya fashion brands. I work with individuals to dress them, personal shopping, personal styling. I also offer group trainings for image. So, lawyers, just shameless plug here, and any other sector that, where your image is important and you need somebody to help you with that, then, I'm the gal for that particular job. You can reach me on, I guess I will share my WhatsApp line, but you can also reach out to me on Instagram. If you're on Instagram, my handle is at Siruma, and Siruma is Ciruma. And I'll also drop my email address in the chat if you want to reach out to me via email. You can also find me on LinkedIn, Siruma Angela Mbare. Thank you. And thanks for having me on this panel. I have learned so much, it's crazy.
Oh, you and me both, Siruma. So thank you so much as well. I mean, yeah, take home, write down your ideas, flesh them out. Don't leave them in your head. Just mood board them somewhere. So thank you so much for that. And last but not least, we have Mr. Sisule from Sisule Advocates. Yeah, and also just for you guys to know, they've also been our host for this event. So thank you so much. So over to you to give your final remarks, and also a bit more about how people can be able to reach out to you and be able to find out a bit more about how you can be able to advise entrepreneurs in all sorts of spaces to reach out in regards to protecting their IP. Sorry, I think we just lost him for a second there. But in the meantime, for those of you who perhaps are able to or joined us halfway through this session, online. So check out the Nairobi Garage website and social media pages as well for that. And also you can be able to reach out to Nairobi Garage as well. So we'll reach the email, even put the email addresses and the contacts also on this chat platform here. Yeah, others, yeah, Sule is back. So over to you.
I think my final message, I think today is to first to recognize the creativity that we are seeing from the youth, especially because of the theme of this year's World IP Day, being IP and the youth and innovating for a better future. I think we are seeing recognition of the innovation and creativity in various ways. The recognition by industry, by governments, of the innovation we see and creativity from the youth, including, as you've seen, I think, in Africa in particular, and more particularly in Kenya, you are seeing the setting up of innovation hubs by Google, by Microsoft, and all those which are creating spaces for collaboration and creativity for the youth. And I think that is a recognition that that is where creativity and innovation is coming from. And so I think my message is that for the youth, for those in the creative industries, IP is important, as I said, not just to protect ideas, but to enable you to collaborate and grow. And so it's important to be aware of which types of intellectual property might apply to your industry, who are the people who can help you be able to protect your IP or be able to license your IP as Mudundo does, for example. It's critical, and I think as Paul has shown, it should not be intimidating. The systems could be complicated in some ways, but it shouldn't be intimidating. Some of the processes are fairly straightforward. So the word intellectual property should not intimidate you. You don't need to be intellectual like a PhD holder to be able to operate in that space. I think that's my final word then to, so Sisule and Associates, LLP, one of the areas we focus on is intellectual property. across the range of the different categories, and we are available to help you navigate both the local, that is the national intellectual property system, the regional intellectual property system, such as the African intellectual property, the regional systems, which are both the English speaking and the French speaking. There is also the international systems that you can use. I think Paul mentioned earlier that a lot of the intellectual property is territorial, that it goes with the territory because different countries have different requirements, but there are ways in which you can shorten that process to get across the world through international systems that are administered by the World Intellectual Property Organization, so we can help you navigate those systems. I should also mention that as you think about intellectual property, I think there's more to it for you to monetize it. It's not just the protection. There's more to it, and so we also think through structuring contracts that will enable you go to market once you have an IP, structuring licensing contracts, as well as thinking through if a business model and which intellectual property, which rights would best suit your model, as opposed to a different model. So for example, the questions around software and patenting, there could be aspects that are patentable, but one has to go through a process of thinking about the model, where you want to go to the market, what is really important for you to be able to structure the right contractual arrangements. So we will put up on the chat how you can reach us. We are also just completing the process of setting up a startup desk that will specifically focus on assisting startups, youth in areas such as intellectual property. It will be broader than intellectual property, but one of the key areas will be intellectual property, where we can provide solutions that are not that are cost effective for you. So we'll put up our contacts, how you can reach us on the chat. And thank you again, everyone. Thank you to Nairobi Garage for hosting us, and we look forward to continue to collaborate. Thank you.
All right, wow, amazing. I mean, you guys have that fast. I mean, in different times, since when has a legal firm ever come and actually set up a startup desk to work with startups and actually be able to come and tap into the knowledge economy? So definitely the times have changed. I know the knowledge economy is everything right now. So I think I'd like to appreciate Sisule for that. And feel free to reach out to them in terms of being able to work together around protecting your IP. So once again, my name is Jesse Moriah. I was happy to be your moderator for the day. Maybe just a bit about me again. Like I mentioned, I'm a board representative of the KNCCI National Chamber of Commerce and Industry. So any of you, after you have been able to protect your idea and you do want to join another community of entrepreneurs, please feel free to reach out to us at Kenya National Chamber of Commerce and Industry. I've left my LinkedIn contacts on the chat there, so you can reach out to me for more information or check us out on our website. Yeah, but otherwise, once again, I really appreciate all of you for coming to join us. I thank Nairobi Garage for hosting us. I thank Sisole for being able to bring us together for this session, and all the great panelists that have been there. Siruma, Paul, Francis, you guys have been amazing. And thank you so much, and do all yourselves a lovely day and amazing World IP Day. So bye-bye, and have a good one. Take care.